Let's talk a little bit about a prefer. A reverse prefer is very different from a prefer. In a reverse prefer, the prosecutor describes the evidence while the defendant and his attorney listens. Sometimes reverse prefers may be done slowly by the prosecutor to the defense attorney. Reverse prefers typically take place when the prosecution wants to convince someone to plead guilty or to cooperate in an investigation. In cases like this, it's extremely imperative that the customer have a great attorney to help him in these situations. Good evening. Welcome to a special edition of the International Grapevine. And tonight we are going to be talking to a great attorney, a good attorney, and we want to have the opportunity to talk to her on the program a little bit as to why we want her to be present. Because tonight we want to talk a little bit about what is a prefer agreement and how it works, and what are the plus and minuses. It can be complicated sometimes, depends on the crime and who is guilty and why they're guilty. When you talk about prefer agreements, it goes without saying that you should have really good legal help next to you if you're a criminal or if you're there for some purposes. So tonight on the International Grapevine, we're going to have the opportunity to talk to a very brilliant and great attorney, Miss Sally Attia, who happens to be our special guest. And it gives us a great deal of pleasure and, of course, satisfaction to have her on the program once again. Sally, welcome to our program.
Thank you very much, and good evening to everyone.
It's good to have you. Like I mentioned, I read a little bit about this so-called a prefer agreement, and I want to take that and expand it a little bit. I did a lot of reading, but I'm not an attorney. But as an ex-banker that have seen so many legal situations, that came up in conversation that I had with other people, and I said, let me see if I could reach you and see if we could do something about that. So I wanted to find out what is the core purpose of a prefer agreement, and why is it referred to as the Queen for a Day session?
Okay. So, a proffer agreement is a really, really important, very useful tool. Um, you enter it when you have a client who's charged with a crime. I know you said they're a criminal. That's not how I like to phrase it at all. But somebody who's been charged with a crime. It's used mostly in federal cases, but you do sometimes have proffer agreements in state cases as well, just not as frequently. And basically, what a proffer agreement is both sides of the aisle, so the prosecutor and the defense, have a written agreement where they say you can come in, talk to the DA's office or the U.S. Attorney's office, and you have to be honest and give them a whole lot of information, and they can't use that information against you in a case in chief against you, which means on their direct case to prove your guilt. But they can use it only in the event that you choose to testify in your case and you say something different from what you said to them at the proffer. And so you're queen for a day because you get immunity. You can't get charged for additional crimes you may confess to or admit to at your proffer session.
In the proffer section, I guess it's extremely important that the person that have whatever legal problems be straight up front when they're talking to that attorney, and obviously how important it is for them to have their own attorney and what picture does he play.
It's incredibly important to have an attorney. First of all, you want a written proffer agreement. So it's signed by both sides. And if you don't have an attorney, you can't verify what I just said the proffer agreement should contain, because if it's not written in the agreement, it's not valid.
It's not
Um,
valid.
right? So if it's not in the agreement, you can't say, well, normally in a proffer agreement, I wouldn't be prosecuted for crimes I admit to. So you need to have an attorney there, first to review this written agreement. And second of all, an attorney's role there is much more than that. It's Your attorney's role is to encourage you and support you. Sometimes talking about crimes you're involved in or other criminals, people, is daunting and scary. Sometimes, although they're not supposed to, but they're trying to find out if you're telling the truth or lying. So they might try to catch you in the lie and trip you up. So an attorney being there is there to protect you, to encourage you, and perhaps to correct any misunderstandings. Also, they're a witness to what's going on. So if you say to the prosecutor, but I told you about this, this, and this, and they're like, oh no, you never told us that. And an attorney's expected to know the stuff, and they wouldn't try to pull that if an attorney's present. So counsel's presence is extremely important at a proffer.
No question about it. I also think there's got to be some type of great preparation by the guy's attorney before he goes in there. He probably get the proper preparation, the things that he can say and he cannot say, and how to carry himself in a professional manner. Because in a preferred agreement, there's some type of give and take sometimes. And if you're not prepared going in, you could walk into danger every now and again, I guess, or I would imagine so.
Absolutely. Prepping for a proffer is absolutely essential. In fact, I got a case where my client got sentenced before he even came to hire me because he got sentenced to a long time in jail. And I asked him, did you have a proffer? And he's like, I did. And I was like, did your lawyer prep you for the proffer and discuss with you what you should or should not say and the extent of truth that you have to convey and what the topics specifically are and how you're going to answer all these questions and how not to not tell the whole truth or how to not just say only one part of the truth, because that's a problem. If you're not giving the full picture, you could be viewed as trying to lie or to deceive the feds in this case. And he said to me that his lawyer never prepped him. He just put him into the proffer and, he didn't tell the whole truth and he didn't tell them parts of the truth that he probably should have, they probably already knew about. And so naturally, his proffer went nowhere, and he got sentenced to a very long time in jail, all because of what happened at that proffer.
Well, it goes without saying, I guess the lack of preparation that he didn't have and changing the conversation and having his attorney present there, I'm quite sure his attorney was not happy about a situation like that because all of a sudden is into a conversation that he was not privy to. But I'm quite sure in a proffer agreement, there's got to be some type of preparation by his attorney as to how to direct yourself, how to carry yourself, and the pros and cons, and what you're going to say. You must be very careful in giving your message because in a proffer agreement, if it's done properly on both sides, there might be some type of agreement. And the only way you get to that is having the proper presentation and being honest upfront to your attorney and to the prosecutor going forward to see if it makes sense to enter into that type of agreement. It's a very sensitive agreement, obviously, and stuff like
Absolutely.
that. Would you have to know what you're doing? And I would have to assume, I mean, I am not an attorney, that most guys or ladies, if they fall into that type of trap, they have an attorney that can represent them and stuff like that. And if you don't have it, you're really walking backward and you're walking backward into all kind of trouble. Stuff like that. If there's a mistake made, can his attorney call for a timeout to speak
Of
to his
course.
client?
So generally speaking, how it would work is first there's the absolute prep that needs to happen beforehand. And that
Yes.
prep happens between the attorney and his client or her client. And also, there's prep between the two attorneys, the U.S. Attorney's Office or the District Attorney's Office and the defense lawyer. And we discuss what kind of information you're looking for and what you're seeking. And then maybe sometimes there is some small level of discovery that's shared so I can better prep my client for what it is that they're looking for or want or trying to find out that he knows about or she knows about. So that's the first step, or first few steps, actually. And then we go into this meeting, and then there's the proffer agreement, the written document that has to be reviewed, and then it has to be signed by all sides at the meeting. And usually, the U.S. attorney or the district attorney will then go over the proffer agreement to make sure that even though the attorney just went over it with their client privately and confidentially, that they also go over it so that there's no lack of communication or misunderstanding about what they're doing. And then the interview, so to speak, begins. And I've always told my clients, if at any time you're unsure, if you don't know how to answer, if you don't know if you want to answer, we always have the right to ask for a timeout, a break, where we have a private, confidential conversation about whatever the topic is or whatever your concerns are. Maybe you don't want to talk about a particular topic at this moment. Maybe you're worried about what they're going to say. Maybe you're not sure if this will hurt you. See, the thing is, in a proffer, you can also tell them about other crimes you've committed, and they can't use your admissions against you, like I said. But they can use your admissions to go find other evidence, and that other evidence can be used against you. And so everything you say can be extremely sensitive and really, really crucial to what you're saying.
Make no mistakes about it. If someone get into this type of preferred agreement, they must have a very dangerous case, and they will have legal representation, obviously. But it's extremely important for them to be honest up front of the things that they are saying to the prosecutor. And that's why the preparation with your attorney is a must before you go in there. You can't go in there and let me use a little street talk. You can't go in there and start playing around and jiving and stuff like that. That's not going to that's not going to cut it with the prosecutors. Those
That's right.
guys are ready to kill if they if they have to. So you have to really take this thing very serious. And I'm quite sure uh, most clients, when they get to it, they get a little nervous when they have to deal with a prosecutor and stuff like that. And when they're giving their answer, I'm quite sure they're staring at their own attorney to see, am I a little bit leaning too much to the other side and stuff like that? Because it's a very sensitive thing, and you have to know what you're doing and how to get into it. If you messed up into a preferred agreement, can you go back to them and say, I made some mistake, can we start over? Or that's not allowed?
It depends how big a mistake, when you want to say you made the mistake. Is it at the same meeting? Did we did we just talk about it and take a break and talk to your attorney and you're like, "Oh no, I realized I screwed up." You know, what is the mistake? What did you misspeak about? So it's all dependent on, it's very fact specific and it depends on the scenario. So what I will say though is, if you've lied, then you need to rectify that sooner than later, because if they catch that lie, well, even if they don't
Down
catch
the
it,
road.
if you lie, you are committing perjury, you are committing a crime. It is a crime to lie to federal agents, and they could prosecute you for that crime.
Wow. What is the difference between a direct use and derived use of information to a proffer agreement?
So that's what I was talking about a little bit earlier. So
Mhm.
let's say I go in and I tell them that I robbed this bank. They cannot charge me with robbing this bank. What they can do, though, is they can go to the bank on that date and time that I told them that I robbed it, and they get and get the serial numbers from the money that was stolen. And if they can tie that money back to me, or if the video shows me in it, that video, those serial numbers on that money that was caught in my possession, they can use that to charge me with robbing the bank.
Wow. These things are very serious. I know for a fact in this so-called prefer agreement, it's very important, as you mentioned, saying the truth, but also extremely preparation in more ways than one, because if you slip, you can go down the wrong way and there might not be any coming back. Um, does this type of agreement are only used on federal criminal cases, or it can be used on any type of case?
I mean, it's used in criminal cases. So they can be federal or state cases. They're most useful or most used in federal cases because usually federal cases run across state lines. Usually they involve an organization of criminals rather than an individual, versus state cases are local cases in that state or in that county that generally aren't as complex. Now, if there is a state case that involves three or four or multiple defendants, and you decide to go proffer, and you decide that you want to um, cooperate against some of the other defendants, that's when you would probably use a proffer in a state case.
Interesting. Um, how does a preferred session allow the government access but as a defendant credibility? What access does he have? Is it before the preferred agreement that there will be conversations between both attorneys and coming to an agreement, or no, everything has to be done rightly and then in conversations?
Before we go to a proffer session, there's an understanding of what the terms of the proffer will be. It'll be discussed and prepped for, because if you haven't already discussed it, there's no way you can prep for it. So you prep ahead of time. Now, what they will do is it is an opportunity for the prosecutor to assess your client's credibility, especially in federal cases. The feds have done their homework. They will be asking you questions that they know some of the answers to already, to assess your credibility, to see if you're being truthful or with them or not. And if they ask and you don't know which questions they know the answers to or not. So they're going to mix in questions they don't know the answers to and questions they already know the answers to. And you won't know which one's which. And if they realize that you're lying to them, then maybe they won't do anything other than just end the proffer session and not agree to work with you in the future. Or maybe if your lies are so egregious, maybe they'll choose to charge you with these frauds.
So if they lie to the government and the government get tired, they just can turn it around and go in their direction, saying, you know what, we're wasting time with you and we're not going to give you any break and we don't want to hear your story anymore. Do they turn around and just get to the point and just say, you know what, we're going to take it to the limit because we find you skipping left and right and not coming through? Or before it get to that, does the attorney stop it and pull him outside and talk to him a little bit and say, stop the, you know what?
Um, if the attorney knows any better, yes. But sometimes we're in the dark, right? Sometimes we don't know what the truth is. Sometimes we haven't had these conversations with our client and we don't know what their truth is. And sometimes they've lied to us. which is unfortunate. You really want to be honest with your attorney. You want to tell your attorney the truth so they can protect you. But if you haven't told your attorney the truth, there's no way for me to be able to prevent you from harming yourself. So, but sometimes if we know that you're not telling the truth, or because of our experience we can tell the feds don't believe you or the prosecutors don't believe you, I would interrupt the conversation and ask to speak to my client on my own and just remind them of the risks they're running and the potential benefits that they're throwing away if this cooperation doesn't happen.
How can an innocent memory mistakes during a prefer session lead to a federal charge for false statements?
So, look, I don't think an innocent memory mistake is a legit argument. Have I used it? Sure. Will I use it? Sure. I have to do what I can to protect my clients. Um, but they're not going to use an innocent memory mistake to charge you. They're going to hound you on it and ask you about it 3, 4, 5, 8 times to make sure that it's not so innocent. They're going to leave it alone, go to another topic, and then come back to it. The whole point of a proffer is to get information. And it's a waste of time to speak to someone just to charge them with additional silly crimes. It's much easier to not have a proffer. But if they have information that's useful, or they think you have information that's useful, and you could benefit and they could benefit, they're going to try to assist you. I put that in quotations, to reaching their goals and helping you in the same time.
Interesting. Very, very interesting. Obviously, obviously, in these type of cases, it is so important to have your attorney and each side. You can't go in with the street talk and thinking that you're going to get over in those places, because the government usually have a strong prosecutor who's pretty good at what he does, and you have to hope and pray that you have a qualified attorney that can represent you. That there ain't going to be no dancing. You got to get down to business. Can a preferred agreement be used to impeach a defendant if they testify is inconsistently at trial?
100%. That's a definite important provision of a proffer agreement. So I can tell you today that I robbed Bank X, and then you decide to prosecute me because we couldn't reach a settlement, and we go to court. You present evidence that I robbed Bank X, not my statements, just evidence. And then I get on the stand and say, actually, I wasn't there on that day. I didn't rob Bank X. I couldn't have. They can absolutely bring in the witnesses from the proffer agreement who will testify and say, on this date, at that time, when you signed this proffer agreement and you swore to tell us the truth, you told us you were there. And so now you're lying to the jury.
Wow. Wow. What are the risks of derivative use when government uses the information to find other evidence? Not,
So,
not
so this is something we talked about, right? When I was using the I robbed the bank example.
at,
You
at the
know,
beginning, yes. Yeah.
if I told you I robbed the bank and you didn't know it was me who robbed the bank, maybe I was fully covered and you couldn't see my face. But I told you that I robbed the bank. They can now go trace the serial numbers of the wads of cash they found in my apartment when they arrested me for this other unrelated crime, and run those serial numbers against the ones stolen from the bank. Now suddenly they can charge me with this additional crime that they didn't even know I was involved in before I proffered.
Interesting. So, for all intent and purposes, we talk about this type of
Just
thing.
before you go there, that's not what their goal is in a proffer. They're not trying to get you to give them information about yourself that they will charge you with. Their goal in a proffer is to gather information, usually about other parties in the enterprise, in the criminal activities, that you can help them gather more information on. In fact, sometimes when you come clean and you tell them all about all your different crimes, other than a weight being lifted off of you for having kept these secrets for so long, they will not charge you with any of these crimes. They may not even investigate them because that's not the purpose of a proffer. The purpose of a proffer is to gather information, usually about other criminal persons involved.
Wow.
So
That
it's
I'm
not about
surprised.
you.
I'm surprised I wasn't aware of that at all. Maybe a little bit naive, but that's kind of surprising to me a little bit. But I guess if you involve into a proffer, you must be some type of classified criminal that been around. If your attorney have to take you into a situation like that to try to help you.
Not necessarily. I've done proffers with people who don't get even charged with crimes. They're just simply being investigated, or their names came up in an investigation of somebody else and they just want to know what their involvement is or what they know about the people who are the targets. So I've had proffers for people who never get charged because they weren't really criminals. They know about criminals. They're criminal adjacent, but they're not criminals.
Well, one of the things that I mean, I heard about in California from two friends of them that I know who felt that they could go in and they would use a I can rap and get over it. And I said to myself, I don't know the law that much, but I don't think in a profit type of thing you can go in and start playing and goofing them. It's not going to go over. And he says, you're a New York boy, but you're not tough enough. I said, that's fine. I don't want to be tough enough, but I don't think you can fool around with these guys. And when you go to court with these type of things, I mean, these guys are there to if need be drive you into the ground. So you have to know what you're talking about and how important it is. How are you going to get over if you can get over? And I'm not an attorney, but I would let your attorney do all the talking. He said to me, "Well, old bastard's going to ask me a lot of questions. I don't know." So no, I'm just telling you, it's dangerous. I'm just by what I read here and there. Um, but it also seemed to me as a proffer, this mostly come with cases with guys who are really truly criminal. It's not the average guy down the block smoking a joint or just fooling around. It's a different type of element, I would say.
So there's a few ways to look at this. Um, in federal cases, generally speaking, it's not a simple case. It's something that's been investigated for a while. In state cases, if they're even interested in a proffer, it's because there are other elements that they want more information on. A proffer could be because you know that somebody committed this heinous crime and you may know where they buried the evidence or the bodies or whatever. So you may not have been involved in the crime, but you know about it. Or you could go in and proffer about something completely unrelated to you that might help you in your situation.
Interesting. How impactful is a criminal case these days? When we talk about an impactful type of cases, and I know two cases in California, but I won't go into it, that just got off a criminal case, and I just said to myself, I won't ask him because those type of things. But I said that it was a very impactful case in Los Angeles. And how do you get off an impactful case that has so many money that you stole from those special stores and that sell chains and stuff like that, and you're recognized? So I consider it an impactful case. How can you get off on something like that?
I guess I'm not sure I understand the question. What do you mean by an impactful case? I because I think anytime you get arrested, that's going to be impacting your life. Um, so I'm not sure what you mean by an impactful case.
To me, an impactful case is a guy who does a large robbery and get away with it. Okay, and they haven't been able to put their hands on him. But many moons ago, he has been to prison. So that's why I use the word impactful, which means that he has some type of background like that. Would they look into that and just bring him and see if they can, that's why I use the word impactful. But again, it's
So your criminal history, meaning if you have a criminal record, it's definitely a factor if you get convicted and you're getting sentenced on another case. Um, in state cases, if you've got a prior felony, maybe you won't be eligible for probation this time. If you've got a prior violent felony, then it'll affect what the minimum jail term will be. That's in a state case. In a federal case, it's on a point system with guidelines and how many criminal contacts you've had, how many convictions you've had, the severity of your prior criminal convictions. They all play out as points adding up to the guidelines range that you will be sentenced to. And by the way, since we're talking now about sentences and guidelines, a proffer, if successful, could lead to something called a 5K motion by the prosecutor. And a 5K motion by a prosecutor in a federal case is really what you're truly looking for if you're a defendant on a serious case, because that can have a massive impact on doing a downward departure from the guidelines.
good gracious almighty. Wow. Okay. Um, Let me just say, I found this very interesting. I did a lot of reading, and I still want to continue doing some more reading down the road. I want to take this opportunity on behalf of the family of Grapevine to say to you, thank you so much for sharing this information, because my program, I like it to be seen all over the place, especially for minorities or whatever. And you came across obviously great knowledge, great presentation, and you open up a lot of things that I never thought about for a second. I mean, well, I never been on the chain gang or anything like that. And I want to take the opportunity to thank you so much for being my special guest and for sharing these moments with us. And hope to have you back in the grapevine pretty soon if it's humanly possible.
My pleasure. Thank you for having me, and I hope I helped.
You certainly helped a whole lot, and I meant that very, very seriously. And it's a pleasure to work with you. This is about the third or fourth time I work with you, and I always leave knowing and learning more. And I appreciate that. I really mean that.
Thank you.
And again, this is Wallingford Lee saying good night for the International Grapevine, and hope that you guys out there would have an opportunity to watch a show of this type of magnitude. Very deep, very informative, and the attorney was right on time, delivering like she should, and like how she knows who. So let me say good night for International Grapevine, and hope to see you next week at the same time at the same place. Good night.